This video accompanies Module 3 and offers an explanation of some of the material in Module 3. At first glance, contract law may seem difficult and complex. There are complicated details about some of the different aspects of contract law, but to a large extent, the basics of contract law are straightforward. There are four elements that are required for a contract to exist: agreement, consideration, capacity, and legality. There are details of each of those elements, but most of those details are fairly straightforward. For there to be an agreement, there must be an offer and an acceptance of that offer. The offer must be sincere, no joking, nothing forced, an intentional offer. And the acceptance must also be sincere. There are some common sense aspects to offers and acceptances. They must be effectively communicated. The person making the offer, who is called the offeror, must communicate that offer in some way to the person to whom the offer is being made, who's called the offeree, and the offeree must accept the offer in a manner such that the offeror knows that the offer has been accepted. Only the person to whom the offer is intended to be made can accept the offer. Once made, an offer does not remain available forever to be accepted. If the offer itself says that it has to be accepted within a specific time, when that time expires, the offer can no longer be accepted. If no time for acceptance is specified in the offer, then the offer can be accepted anytime within a reasonable time after it's communicated to the offeree, and what's reasonable depends on what the offer is about. The offeree, who receives the offer, has three choices. They can do nothing, in which case the offer will expire either within the time stated in the offer or within a reasonable time, and there's no agreement. They can accept the offer which has been made and communicated to them, in which case there is an agreement, or they can actually reject the offer, refuse the offer, in which case the offer ends, and if the offeree then changes his or her mind and wants to accept the offer, it's too late, because once the offer is accepted, the offer cannot be, once the offer is rejected, the offer cannot then be accepted. The second element of contract is consideration, and that deals with what each party to the contract receives as a result of the contract. Each part of the contract either has to get something that they weren't otherwise entitled to get, or they have to give up something which they weren't already required to give up. Essentially, each party to the contract has to receive some benefit that they're not already entitled to receive, or give up something that they're not already required to give up. Usually, consideration for a contract is expressed in terms of money or things, but it can also, it doesn't have to be something tangible. It can be a promise of future action. In what's called a bilateral contract, each party promises to do something specific within a certain time period, and once that exchange of promises occurs, the contract is created. And so the consideration for that contract is the promise, not money or a particular thing. Consideration does have to be something that a party to the contract doesn't already have an obligation to do. If I promise you that I will perform a duty that I already have a legal obligation to perform, then my promise to you is not consideration. And consideration also has to be something that has not already been done. If I tell you that I washed your car last week, the fact that I washed your car last week and I want you now to agree to do something for me isn't consideration, because I've already done what I offer as consideration without the promise, any kind of promise in return. And consideration has to be real and definite. For instance, if I tell you, if you paint my house and I like the job you did, I think you did a good job, I'll pay you $500. That's not a contract, because the condition that I have to be satisfied with your performance means that I really haven't promised to do anything. Third element of a contract is capacity, which simply means that the parties to the contract have to have legal and mental ability to make the agreement. Capacity arises in three basic situations. Party to a contract, in most cases, must be an adult, and that's 18 years old under the laws of most states. Also, a person who is so intoxicated by whatever means and under whatever circumstances, if they're so intoxicated that they can't understand that they're making a contract and that they're assuming some obligations under that contract, then they don't have capacity to contract. And if a person has been determined by a court to be incompetent, mentally incompetent, or is actually mentally incompetent at the time that a contract is allegedly made, then they don't have legal capacity to make a contract either. Legality, the fourth aspect of a contract, the fourth element of a contract, simply means that the object of the contract, what the contract is about, has to be legal. So, for instance, in a state that doesn't allow gambling, if we make a contract that is a gambling contract, it's not a contract because the object, gambling, is not legal in the state. In a contract case, you are typically called on to determine if there's been a breach or a violation of contract. And to do that, there are certain steps that you should consider in making that analysis. The first question is there a contract? And the simple answer to that is that if the elements of the contract are present, then there is a contract. So if the four elements of a contract, agreement, consideration, capacity, and legality, are present, then there is a contract. Once that you know that there's a contract, then the next question is, has a contract been breached? And that's a matter of whether what was promised in the contract has been done. If it has been done, then the contract has not been breached. If it has not been done, then the contract has been breached. If you have a contract that has been breached, then the third question is there some excuse for the failure to do what the contract required? There are a variety of excuses. For instance, impossibility of performance, also sometimes called commercial impracticability, means that a person who was supposed to do something specific under the contract simply can't do it now because of circumstances that have changed. So if I'm supposed to wash your car for $20, but your car is stolen, so it's not here, well, I can't wash your car. I've not breached the contract because it's impossible for me to do what I'm required to do under the contract. The catch with impossibility of performance is that the thing that makes the performance impossible has to be something that the parties to the contract could not have reasonably anticipated when the contract was made. I agree to wash your car for $20. We don't have any reason to think that it might be stolen. It is stolen. It's impractical. I can't perform under the contract. If there is a contract and the contract has been breached and there is no excuse for the breach of contract, then the last question is, what damages does the non-breaching party to the contract, what damages are they entitled to recover? Typically, the non-breaching party can recover compensatory damages. What amount of money is necessary to pay to the non-breaching party to put them in the position they would have been in if the contract had not been breached? That's usually a comparison. You hire me to wash your car for $20. I don't do it. I just didn't do it. Not because the car was stolen. The car was there. I just didn't wash it. So you hire somebody else to wash the car for $25. The compensatory damages to you that I have to pay in that case is the difference between what you would have paid me, $20, and what you had to pay to get the work done, $25. That's clearly just an illustrative case, but you can see that the damage, the amount necessary to put you in the position you would have been in had I not breached the contract, was $5. Okay, well, if there are any questions about any of that material or any material in Module 3, please let me know, and I'll do my best to provide some additional information.